The third and perhaps the most vital organ of a democracy is the judiciary. Although our political system is federal in nature, with a dual set of governments, the judiciary is single and unified. Its function is to administer justice in a civil society and interpret the laws and protect the natural rights of the citizen in this free country. It also safeguards the Constitution and examines the constitutional validity of the state and union laws. That's why it is also called the custodian of the Indian Constitution. Before going to the lesson, we can mark the syllabus for this lesson. First one composition, second one qualification of judges, third one appointment of judges, and fourth and last one jurisdiction and functions. Under the jurisdiction and functions, we'll be studying around 7 topics under that. First one original jurisdiction, second one appellate jurisdiction, third one advisory jurisdiction, and the fourth one revisory jurisdiction. Number 5 judicial review, number 6 court of record, and the last one enforcement of fundamental rights. Composition of Supreme Court. At the commencement of Constitution, there were 8 judges including the Chief Justice in the Supreme Court. The Parliament can increase or decrease the number of judges as and when is required. The Supreme Court of India consists of Chief Justice of India and not more than 33 other judges, and this can be decided by Parliament of India by laws. Qualification. A judge of Supreme Court must be a citizen of India. Second one, he must have been a judge of one or more high courts for 5 successive years, or be an advocate of one or more high courts for 10 successive years, or be an distinguished jurist, distinguished mean well-known jurist in the opinion in the sight of President of India. Appointment. Every judge of Supreme Court shall be appointed by the President of India. For the appointment of Chief Justice, the President consults those judges of Supreme Court and the High Courts as he deems necessary. A Supreme Court ruling indicates that the senior most judge of Supreme Court should be appointed to the office of Chief Justice of India. In appointing other judges, consultation with the Chief Justice is compulsory. Of course, it must be noted that the advice of Chief Justice will not be binding on the President unless the recommendation are supported by the 4 senior most judges of Supreme Court of India. When the Chief Justice is unable to perform the duties of his office by reason of absence or otherwise, the President may appoint another judge of Supreme Court as the acting Chief Justice. Jurisdiction of Supreme Court. What is jurisdiction? Jurisdiction is the power that the court of law exercises to carry out judgment and enforce the laws. First, we can learn about original jurisdiction. Article 131 of the Constitution spells out the original jurisdiction of Supreme Court. The original jurisdiction empowers the Supreme Court to hear and decide certain cases in the first instance, which means those cases cannot be heard by any other court in our India. We can check now some examples under the original jurisdiction. The first one, a dispute between or the problem between Government of India and one or more states. Second one, the dispute between 2 or more states. The third one, the dispute between Government of India and any state or states on one side and any other state or states on the other side. Apart from these three cases, Supreme Court can involve some cases as the original jurisdiction. Under that first one, it is empowered or Supreme Court is empowered to issue direction or orders or writs for the enforcement of fundamental rights. It can issue the writs like habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Second one, Supreme Court having the power to decide the constitutional validity of the laws passed by union government or central government. The Supreme Court also have the rights to incur, the decide all disputes if any connection with the election of President of India and Vice President of India.